Hi, I'm Catherine Ballantyne, a partner at Madgwicks Lawyers. This case update comes out of the Victorian Supreme Court and relates to a transfer of property as a gift from mother to son. It's the case of McFarlane and McFarlane 2021 VSC 197. In this case, back in 2015 or late 2015, Judith, the mother, transferred as a gift to her son our property. The son's name's Mark. She also had another daughter, Nicole. In 2016, Judith was put into a home, and in 2017, the state trustees were appointed as her legal administrator. Essentially, what a legal administrator does is make decisions for and on behalf of the person over whom they have been appointed. VCAT will make this appointment and will do so when they believe that the person has a disability and is unable to make reasonable decisions for themselves. Now, the state trustees brought this claim to say essentially that the transfer of land was unconscionable and occurred because of undue influence by Mark on his mother, Judith. Now, there was a host of evidence given at the court. Judith gave evidence that she was scared of her son, that he yelled at her, he sometimes withheld her medication. Nicole gave evidence that he, when she visited, sometimes he pushed his mother or withheld her food if he didn't feel that she was doing what he required. And the court became involved to decide whether essentially to give Judith back her home. Now, the court held that undue influence can occur where one person is in a position of influence or trust over another person. Essentially, in the case of a transfer of property, it's where the stronger person benefits from the decision of a weaker person. And the stronger person has to demonstrate, if they don't want that transfer set aside, that the weaker person made this decision of their own free will, that they were fully informed and made the decision themselves, that there was no undue influence or unconscionable behaviour. In this case, the court found that Mark had preyed on his vulnerable mother with whom he lived. He lived with her for about 4 years prior to her going to the nursing home, and that she hadn't made the decision of her own free will. He'd taken her to the lawyer's office. He'd made the appointment. He'd spoken to the lawyers. He took her to the lawyer's office. A trainee lawyer witnessed the transfer of land, and at no time did Judith, the mother, obtain any legal advice or even see a lawyer or have any conversation with a lawyer on her own to understand the effect of what she was signing. So the court took a very dim view of what had gone on, and they set aside the transfer of the property and returned it to Judith. And they put her back in the position as if it hadn't occurred. So Judith had suffered some losses. Her aged care benefit had gone down because of this gift, and she'd been unable to pay a deposit on her accommodation at the aged care home, and therefore her weekly payments had increased. So essentially the court ordered that the property be returned to Judith, those payments be made by Mark to Judith. He put her back in the place as if the transfer hadn't happened, and he paid her legal costs, or in this case, the state trustees' legal costs. So what comes out of this is that the court takes a very dim view of these matters, and that if you believe that a transfer of land or any other property has occurred due to undue influence or unconscionable behaviour, it's really important that you act on it. You may need to take it to the courts, and if it's a person in a vulnerable position who doesn't have the capacity to make their own decisions, you may need to get an administrator appointed, whether that be a relative, the state trustees, or a private administrator, in order to progress matters and look out for the best interest of that person. I hope this was helpful. Thank you.